Well, I'm thrilled to be here. I'd never been to Ottawa. I've been all over Canada, but not Ottawa. And people keep asking me why that is. And I guess unless you have a political agenda, Ottawa is not necessarily on your dance card, which is a shame because it is absolutely gorgeous. I was out this morning running along the canal in the dark, looking up at these all uplit buildings, and it is spectacular. And I think largely unknown to us gringos. So I'm really happy to do it. I thought I would talk a little bit about some of the history in the high-tech world of intellectual property and why it is a critical asset not only to companies but to countries. Obviously, that report that's been bandied about is sort of, think about it as a call to arms, a wake-up call, I think, to Canada and Canadian companies to say, you know, there's another game afoot, and you all ought to think about it. We can all debate the solutions once we know what the problem is. I'm going to talk a little bit historically about how this has developed in the United States. I'm going to use a few examples. I'm going to use IBM. I'm going to use AT&T, at least the old AT&T. The new one is a division of the old one, and Microsoft. And finally, I'd like to talk a little bit about the world of NPEs, or if you prefer, patent trolls, and the world of smartphones. And I'll finish up with some general rules based on what we talk about today that might help some of you who are in the trenches dealing with IP issues. And then if we have any time left over, we'll do some Q's and A's, hopefully. I'm actually more thrilled to be in front of what I would call a general audience, because it's starting to demonstrate, at least to me, the importance of the concerns over intellectual property assets and their role in the competitiveness of companies and nations. Now, a couple of years ago, I would say within the last 2 years, and prior to that, if I had given a speech similar to this, I would be in front of a IP audience somewhere, to the point that I would know the name of virtually every participant in the room. And it wouldn't matter where the hell that speech was in the world. It's the same suspects would show up. And we kind of all sing to ourselves, you know, and then we'd have church over there and choir practice over here. But it was the same group of people. So what's nice about this meeting is it's not the same group of people, and it's other people trying to come involved in this. Now, I know I'm going to start with some specific examples. And I know that means that this little history I'm going to go through is imperfect. I accept that. But there are two reasons for it. One is these are important examples, as flawed though they will be. But the second reason is it's all I know. So stick with me, because if you make me venture from this, I'm going to fail. So I'm going to start in the 50s, when I was a little kid. And 1956, to be exact. By the way, I was not following this stuff in 1956. But there were, in that year, 2 settlements of 2 major antitrust suits. One with IBM and one with AT&T. And the output of that settlement were something in the United States legal system called consent decrees. Consent decrees are judicially enforced settlements where the defendant doesn't have to plead guilty, basically, but is. And that's why they signed the consent decree. They'd never admit that. But what the consent decrees in both of these cases did was require the companies to license their intellectual property to all comers under something called reasonable and non-discriminatory terms. Shortened today as RAND. That's what that means. Now, why was it important? Well, there were 2 major technology research labs in the world at the time, pretty much the world, especially in IT or computers and communications. One was called Bell Labs, pretty famous place, and the other one was the Watson Research Labs of IBM. By the way, of the 2, only the Watson lab is left. extant. But they were generating all the stuff in the communication controller world, which were basically communication controllers are specialized computers, and IBM, which was doing all the research pretty much on chip making at the time and on computers. Now, that decision to sign those consent decrees had pretty far-reaching implications. I'll just give you a couple. One was the rise of Japan. Now, in the mid-50s, what did Japan do? It made little tin model cars for sale at Christmas time under your tree. It's hard to remember that, but that's what Japan was turning out. Japan was below Southeast Asia's economic production today in terms of the kinds of things it did. It was the lowest of the low in terms of what it could produce. By the way, the United States was scared to death that Japan would lose its position as the world's largest aircraft carrier, which is what the United States was concerned about. They really wanted to make sure the Japanese economy didn't sink. Of course, those of you of a certain age, which include myself, would remember that the world was scared to death that the communist march was going to take over and Japan would be next. That's why the U.S. still has army bases all over Japan. But in any event, that was the climate. AT&T was in the same boat as was IBM. So what you had was a second economy, Japan, coming up, using the architectures and the technologies of the two companies that had to give it to it under favorable licenses, IBM and AT&T. It is no accident that all the computers that Sony, Toshiba, Fujitsu, Hitachi, Mitsubishi, at least those, built looked exactly like IBM computers. Why shouldn't they? They were getting all their information and technology basically free from IBM. Same is true with communications controllers. So in a sense, you had this licensing practice, government enforced, for the rest of the world using those two companies' technologies. What did the companies get back in return? Well, think about IBM and AT&T. They were up to their fetlocks in antitrust problems in the United States. They were not about to start taxing companies for their licenses that they were going to give out, or they'd be back in the antitrust suit even quicker than it turns out they were. So they took freedom of action back from these other companies that they would license at the end of the day, which means they didn't really license them for money. They were already making all the money they could. AT&T because it was a legislated monopoly in telecommunications, IBM because it was basically a monopoly in mainframes, although not adjudicated as one at the time. So you can see what the licensing practices were in those two industries at the time. Well, it turns out, I'm paraphrasing my own speech here, so I'll try to get most of these points. IBM and AT&T's concerns were well-founded. They were back in the antitrust soup a little over a decade after that. When I joined IBM in 1971, they were a year into what would be a 13-year antitrust suit with the United States, and that was followed by about 100 private antitrust suits in the United States at that period of time. The reason I joined IBM, it was a great place to be an antitrust litigator, which is what I was at that time in my life, or at least I thought I was. And so that was really a cool place to be. Well, by the early 80s, AT&T had begun to divest itself. It was being broken up by the government, and you know you had Southwestern Bell and this Bell and that Bell and whatever Bell. Southwestern Bell, I think, is the current AT&T. Actually, one of the children of AT&T became the parent. IBM was more successful. IBM was never broken up. The Justice Department suit against IBM was dismissed in I think 1983. Mostly because of mismanagement, I must say, on the part of the Justice Department. They did a horrible job. IBM did a great job of dragging that thing out as long as they possibly could until everybody just kind of collapsed out of exhaustion. However, IBM was, as a result of all of that litigation and the threat of it, extremely cautious. And now that caution was judicially enhanced. It was caution on steroids. And it caused IBM to miss a few things. The mini computer explosion, frankly, the full breadth of the personal computer business was missed by IBM. I know I was the general counsel of the personal computer division when it started, and our forecast worldwide for all personal computers over all time was 150,000. And they would sell for $2,000 a piece. And I can remember sitting in front of the board and the chairman trying to get funding for this crazy business, and the chairman saying quite rightly, we sell one mainframe computer, we have eaten up the entire profit of the personal computer forever. Well, you can imagine what won inside of IBM. It was not the personal computer. And the rest, of course, yesterday's sad events with Steve Jobs notwithstanding is kind of history. So, but while that's going on, while AT&T is breaking itself up, and while IBM is sitting there wringing their hands over what to be when it grows up, their research engines were cranking out enormous amounts of patents and intellectual property. That never changed. So I'm coming out of my Japanese experience now. I'm back in the United States, and I'm watching IBM sink. By 1992, IBM was down to 100 days of cash. IBM was about to go out of business, basically. We're getting ready to file for bankruptcy. Lou Gerstner comes in as the new CEO, and that's the situation I found myself in as I took over the IP operations of the IP company, of IBM. Why did I do that? Well, I'd been bemoaning the fact that IBM was late to turn the switch, to realize it had this enormous intellectual property position that it was basically giving away for free. And my argument had been that times had changed. There's no reason not to get recompensed for the amount you'd spent on the R&D. Otherwise, you're just giving it all of that away, and there's no point in having it if you don't do that. So fortunately, I was in between CEOs, and I started doing it that way, and there was nobody left to stop me. In 1991, IBM, by the way, was a net payer for intellectual property. We paid out $150 million in 1981 to other companies for that same freedom of action I talked about. By the year 2000, we were making $2 billion a year on our licensing thing, and we had 1,826 license agreements. That's 1,826 different companies around the world that had some relationship with IBM. And by the way, that $2 billion we made that you heard referred to earlier on an annual basis cost me $36 million to get. Well, that's a pretty good return. And it makes you a real hero to the CFO of the company, by the way. And you don't have headcount arguments and all those other things that we're all too familiar with. So IBM lays off 200,000 employees in 2002 and 2003. Massive, massive layoff. And Lou Gerstner is in his second day in the office, and he picks up the phone and he calls me and he starts screaming at me. I knew him well because his brother is my closest friend. So Lou is screaming at me about what the hell did I think I was doing licensing IBM's technology out to erstwhile competitors, and hangs up the phone. So we're sitting around kind of trying to figure out what we're going to do about all that. And we came up with a pretty good idea. We took an IBM laptop, which doesn't look any different from laptops today, really. The guts are changed, but they look about the same. And we took off the cover of an IBM laptop. Remember now, this is an IBM architecture. And we made little flags out of toothpicks and little red flags, and we glued them literally to the IP of other companies, obtained through all those years of licensing that freedom of action stuff that we had done. And we stopped at roughly 150, 160 toothpicks because we ran out of the ability to glue them on there because of our fat fingers. I mean, it was that's the reason. We could have gone on and on and on. That's a pretty nice little graphic, though. And we walked into Lou and put it on his desk and say, here's why we do licensing. This is our architecture, and we can't build it without the IP of others. It's the start of the open innovation conversation. Lou looked at that, took him about 2 seconds and said, you're right, you guys are in business, go do your thing. So that continued, and that's kind of the IBM story, and you know, I kind of gave you the end of it. Well, I won't go through the politics of that. You can imagine the incautious nature of IBM, and some of the other people were just devastated when we moved to that model, but it's turned out to be a pretty good one for IBM, and it still is. Lou's reaction is very typical to most CEOs and CFOs today, and this has nothing to do with being a Canadian CEO or CFO. You could scratch a CEO anywhere and you get the same reaction. Intellectual property exists to stop somebody else from doing the same thing you're doing. That's what it's for. It's what's called a negative right. It's never used in a positive fashion, a licensing fashion. You stop somebody. Now, why did Lou think that? His CEO experience consisted of Nabisco, which makes cookies. And in the 80s and 90s, there was a great time when they were all suing each other, something called the Cookie Wars. There was a book on the Cookie Wars. I tried to find it on Amazon the other day and I couldn't, but there was a book at one time called the Cookie Wars. And so and by the way, Procter & Gamble stopped Nabisco from producing soft chocolate chip cookies in a patent fight. So Lou's view of that was that way. Now, take it one step further. Why is it that way? Why is his view that way? Well, those of you, again, of a certain age who went to business school and law school or accounting school will remember nowhere does anybody teach you anything about intellectual assets. Why is that? Because they're not on your balance sheet. What's on your balance sheet? On the asset side, property, plant, and equipment. Hard goods, things you can feel and touch, not intellectual assets. Well, if it isn't on your balance sheet, it doesn't exist. And if it doesn't exist, it can't be measured. And no CEO is going to go to the board and say, let's talk about airy-fairy stuff that doesn't exist on the balance sheet. That doesn't happen. So the world marches on. We're at the point today where most economists think that somewhere between 70 and 80% of the value of a modern corporation is intangible assets. 70 to 80%. That's trade secrets, that's patents, that's copyrights, that's trademarks, all that stuff adds up to about 70 to 80% of the value of a corporation. Imagine that. So we're in a situation where you are telling a general who's about to fight a battle, guess what? You don't know where 70% of your troops are. That's the situation we find ourselves. That's what that monograph at the end of the day is really about. So the question is, what are you going to do with all of that? Fast forward to Microsoft. Now I'm at Microsoft, quite by accident, I might add. What's Microsoft need? Well, it sure as hell doesn't need cash. Microsoft at the time had $30 billion in the bank. Today it's got $58 billion in the bank, and a lot has transpired since that time. But Microsoft, the last thing it needed was cash. You look around at Microsoft, you find the following in 2003. Doesn't have an IP portfolio outside of copyrighted software. Why is that? Well, software patents were kind of new, and nobody bothered to get any. So Microsoft couldn't do any real licensing because it had nothing to trade. So the first goal was, let's get Microsoft's intellectual property portfolio up to world-class standards. And we spent 3 to 4 years getting Microsoft to where it is today, which is the second largest US-based patenting company in the world, IBM being the first. And sandwiched between those is a small outfit from Korea named Samsung. But that's kind of where what Microsoft needed to do before it had something to even use as trade bait. Well, what did Microsoft need? Well, if you looked at Microsoft as I did coming in from the outside, Microsoft grew up in a kind of a damp corner of the United States. Those of you from Vancouver, I apologize, it's the same weather. But a damp corner of the United States. It grew up all by itself. Here's this company at the time with 70,000 employees all on pretty much one campus. They all breathe the same exhaust. And they all think because they made more money than anybody else in the history of mankind, they were a fortiori the smartest people in the world. That's the culture. That and not wearing shoes, I guess, was the culture. So you look at that, and it should be no surprise that Microsoft didn't have a whole lot of friends in the world. It didn't need any. Bill Gates and Steve Ballmer spent no time on Wall Street because they didn't need any funding. They had no political friends because they didn't have any political offices, because who needs them? They didn't have any commercial friends, really, outside of customers and suppliers. So when they got in antitrust trouble, they had no place to turn. There was nobody who stood up in the corner with Microsoft and said, yea, verily, you've provided software here that literally has changed the world. Virtually every company in the world uses Microsoft Office or uses Windows in some way, shape, or form. By the way, somebody want to guess how many lines of code are in a current version of Windows? 53 million. So those of you who bitch and moan about how come this doesn't work with that, try to do product resolution over 53 million times whatever it is you're trying to do. But that's an aside. So what Microsoft needed was relationships. They also had some very onerous terms and conditions to deal with them in their non-disclosure agreements and everything else. They enforced a unilateral patent piece, something called through non-exertion of patents, clause in there that said if you want Windows, you agree never to sue anybody for patent infringement who uses Windows. That's pretty much everybody. And if you're Fujitsu and Hitachi, you're not happy about that. And Microsoft got an antitrust suit for that in Japan. So that's Microsoft's problem. The way to get around that was to come up with some way to build commercial relationships, and the way to do that was embarking on a licensing program, and the way to do that was have a world-class intellectual property portfolio. All we did. And so when I left Microsoft, they had over 600 of these license agreements in a much smaller industry than IBM. But that's 600 companies who aren't going to sue each other. You should think about these license agreements as mini peace treaties between companies, because that's what they are. And so Microsoft ends up with 600 of them. Their legal situation, except for this NPE question, which I'll get into in a minute, was a lot better than it had been there too. By the way, both IBM and Microsoft got to those particular points in their history without one piece of litigation, which I think is quite remarkable that you could do that. So those are the two stories. They're very different, but they both demonstrate that irrespective of where you are in your particular industry, or I would argue your country's competitiveness, you're never too late nor too underdeveloped to compete in this new world of IP ascendancy. Which brings me to the next chapter, where we are today and the latest kerfuffles over smartphones and NPEs, or trolls if you like, and in a world characterized by many as one of excess litigation. I mentioned this is a general audience, largely here because of interest in this subject. And why are you here? Well, you're here because of the following headlines. I'll just pick some from the last month. Android no longer a free agent after the Microsoft-Samsung deal. Microsoft-Samsung deal strikes a blow at Google. Google acquires Motorola Mobility and its patents for $12.5 billion US. Microsoft and Apple purchase 880 Novell patents for $450 million. Google buys 1,000 patents from IBM. Apple, Microsoft, RIM et al. Buy Nortel patents for $45 billion. By the way, that's $750,000 a patent. Oracle sues Google for $6 billion over Android's alleged infringement. Those are just some recent ones. I could have gotten more out of today's newspaper had I wanted to read it or had had time. Now, each of you has a chart that you got at your table. This is the circular firing squad of the smartphone industry. I might add that that chart is incomplete. That chart's a month old. It came from The Guardian. And what it doesn't have on there are the 406 suits that Samsung and Apple have filed against each other around the world. And I'm slightly exaggerating the number, but I'm not sure I am. But there's your industry right there. You might ask, why is this? Why isn't it like the computer industry or the communications industry? Why all of a sudden? Well, there's two reasons. One is those smartphones have become a new platform. Just like a computer is a platform for application software and other things you want to do with it. Or a communication controller is a platform so that other people can make phone calls and fax things. A smartphone is a platform so you can have applications and you can do this, that, and the other thing. That didn't exist 3 or 4 years ago. 3 or 4 years ago, generally speaking, a phone was to make phone calls with. Now the last thing I do with my smartphone is make phone calls, right? I do everything else on the damn thing. I keep my calendar, my contacts, blah, 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 blah. That's the first reason. The second reason is that industry grew up really quickly, and without that umbrella of passivity enforced by the IBM or AT&T required open licensing practices at the time. So there was nothing there, and this is what you have as a result. So, that's the world you're in. You overlay this with a kind of a troubling new class of litigation, and that's suits by these so-called trolls or NPEs, and things get really interesting. The problem with NPEs, there are a couple of them. One of them is you can't define what it is. A lot of people say, well, non-performing entity, that makes them bad. They're not doing anything. They're buying patents and just kind of terrorizing people with their brand of asymmetrical warfare, because you can't sue them because they don't make anything. And that's true as far as it goes, but try to define that sometime and without sweeping up every research university in the world, which would be a huge mistake. You want to say that Stanford or MIT or McGill or University of Toronto, those are NPEs or trolls? I don't think so. So you have to figure out how you're going to do that. Did you think that IBM with 66,000 patents, or Motorola with about 60,000 patents, or Samsung with about similar numbers? Do you think they practice every one of those patents? They don't even know what they all are, much less do they not practice them. Yet they license them. They bring them into the table into the negotiations, but they don't practice them. Are they NPEs at that point? Probably, to some degree. So it's been very hard to define what an NPE really is, and that's why you don't see any realistic attempts to ban NPEs from the litigation parade. So let's talk about that. How bad is it really? I wrote a piece 2 weeks ago, I think now, for Forbes magazine on this point. I'll spare you reading Forbes magazine here. And I'll just give you what the sum total of it is. If you talk to Paul Michel, who's the chief judge, retired chief judge of the Court of Appeals for the Federal Circuit, which is the U.S.'s highest IP court, he would argue that litigation is largely unchanged in the United States. There were 3,000 patent suits, basically extant every year in the United States for the last decade. That has not really changed. Of those, 2/3 never see the light of day. They are negotiated away or dismissed in pretrial motions. I'm sorry, I gave you the wrong number. 90% of those are abandoned or settled. Of the 300 that remain, 2/3 of them never see a trial. That leaves you about 100 patent infringement suits in the United States a year. That's it. Now, they get a lot of attention. There's no question about it. And they're expensive. And my former companies have paid a lot of those settlements because they are so expensive. But I just want to put this in context. You're talking about a country with 2.5 million patents in force, and hundreds and hundreds of thousands of competitors out there using the court system. So I think you could come to a pretty good argument that the court system isn't being terribly abused by that. Some would argue that there are certain jurisdictions that are out of control. The head of the, let's put it this way, one of the principal judges of the Eastern District of Texas' son runs the largest patent trial firm in the same town. Some have raised eyebrows over that. And there's some things like that have gone on. But generally, I would say that the court system in the United States is in pretty decent shape, and there's two other reasons. The Supreme Court and the CFC are starting to limit what you can do in terms of remedies. It used to be automatic. You could get an injunction against someone who is found at the trial level to be violating your patent. Think about that for a minute. An injunction against Windows, millions and millions of copies out there, is a devastating thing. Devastating thing, and it leads to that asymmetrical balance of power in the negotiations. So injunctions have been limited to those who are actually in the business, those who are actually making things. Automatic injunctions. I think that's probably a good change. The other change is they have tightened the rules of what's patentable in the United States, so that non-obviousness, which is a precondition of getting a patent, has been tightened up quite remarkably, and that's really a good thing. I'm going to make a quick prediction. Within a decade, all of this stuff on that circular firing squad will be gone, except those light gray ones. That's the NPE ones. I think there's precious little you're going to do about those. But I do think what's going to happen in here that the companies are all going to realize that they're not going to go away. Samsung isn't going to go away. Apple isn't going to go away. Microsoft isn't going to go away. Google isn't going to go away. Blah, 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 blah. These companies are not going away. And the only thing they're going to end up at the end of the day doing, unless they want to just enrich law firms for the rest of everybody's lives, is they're going to have to do license agreements with each other that allow for this transfer of technology, and I think that's what is likely to occur within the next decade. So here are a few quick thoughts on where we go from here, and if you're in the IP business back at the ranch. First one is that unless you're a design house like Qualcomm or Rambus or somebody like that, your IP needs to serve your business, not be your business. IBM and Microsoft succeeded in their IP structures because we found ways to make them fit into what the needs of the business were. In IBM, it happened to be cash. In the case of Microsoft, it happened to be relationships. But you need to find something in your business that makes IP important to the business, not just because it's IP. As fun as that is for those of us who wallow in it, that isn't the way to really be successful. My view, is second point, is that you should leverage your inclusivity, not your exclusivity. In other words, use your IP for outreach, not fortress IP kind of thing. I think you'll be better off. I think that's a lesson, again, I go back to the smartphone thing, that they're all going to learn here in fairly short order. Third point, which is a corollary to that one, is money isn't money anymore. The value for your IP comes in lots of flavors. Lots of flavors, not just on the balance of payments between my pile is bigger than your coal pile kind of thing. Think about relationships, think about common ventures, think about market access, think about standards, think about political necessity. All those things are relevant. Third point, licensing is really deal making. That's what we're talking about here. That's all it is at the end of the day. It's just a different kind of a product. Fourth point, fourth point is another corollary. License equals collaboration, not sales. It's not just sales. You just don't walk in and clobber somebody over the head and say, pay me, and walk out the door. Final point, most important, goes back all the way to the beginning about this accounting thing. Leadership can't be outsourced. If your company or your country is going to embark on a leading edge IP journey or strategy, the top management of that entity has got to own the process and own the results. So thanks, and I'll stop there, and if there's time for questions, we'll do that.